everyone. Today is Thursday, March, no, what are we in? April 18th, 2024. And welcome to Will Work for Food, the New Possibilities Hour. It's going to be another great presentation this morning. For me, it's morning, so I say good morning, but good afternoon, good evening, wherever in the world you might be. Our program today is aggressive resolution management, early resolution options, what clients want to know. For many of us who were in practice for years before becoming mediators or arbitrators, you just picked up the phone and you made a call, right? And you talked to the other lawyers, or you talked to the other party or the claims representative or whoever it was. So a lot of that is not the norm so much anymore, and we're going to hear more about it today with our excellent speakers, Eric English and J. Patrick O'Malley. But that said, first, let's get to the numbers part of the presentation and find out how much we've been told about in donations so far since May of 2020 when this was first founded. And these are donations to food banks around the world. So, Jeff?
Thank you, Jean. It's a wonderful number to announce today. So far, our generous audiences have contributed $560,227.17 in honor of our great speakers. Thank you all very much. Jean, back to you.
Oh, thank you, Jeff, and thank you all, and anybody watching this on video later on. That's just fantastic. Please feel free, donate often and early or whatever you are able to do, and then please let us know about the amount you donate, one of us, Jeff or Natalie or myself, so that you can, so that we can add it to this running total. I can see 600,000 coming up real fast here. So that said, let's get on with the show, so to speak. Let me introduce our speakers first and foremost. They are kind of hidden over here. They've got their PowerPoint on and ready to go. So at this point, you're seeing them in the corner there of the PowerPoint. Eric English. Eric has focused his practice on serving as settlement counsel since 2003. He represents individuals, corporate clients, religious organizations, class action parties, public entities, and a wide variety of complex disputes and litigation. And he also mediates complex business disputes. His background is as a trial lawyer in private practice, as chief litigation counsel, and as general counsel. Senior management, serving on boards of directors. So he's seen an awful lot, done an awful lot. And he even studied law in Melbourne, Australia on a Rotary Fellowship. So he is quite accomplished, and we're very happy to have him here today, coming to us from Oregon this morning. J. Patrick O'Malley. Pat, he also brings a deep background in business and litigation to the role of settlement counsel. He has had over 15 years in private practice, trying cases, handling complex business and real estate matters, followed by 7 years of in-house management, where he headed a number of legal and business departments. They have a mediation company, Resolution Strategies, and they mediate and resolve a wide range of disputes there. Pat stayed close to home at the University of Oregon. He was in their honors program, and he was the associate editor of the Law Review at the University of Oregon Law School. So he later founded and served as president of the State of Oregon Sports Hall of Fame and the museum. So that's a little interesting tidbit. That said, these are just very nice gentlemen, very nice people, and we look forward to what they would have to say. Their suggested food bank is the Oregon Food Bank. So why don't I turn it over to you, Eric and Pat, and if you could just tell us a little bit about your food bank, and then the floor is yours to launch into your presentation. That would be wonderful. Thank you.
Thank you for that gracious introduction. I appreciate it, Gene. The Oregon Food Bank, and as you can probably tell from my accent, I'm not an original duck like my business partner, Mr. O'Malley. But the Oregon Food Bank has done a lot of things that many of the food banks throughout the world have, collecting and distributing food across Oregon, but also Southwest Washington. One of the things that we like about this Oregon Food Bank is that they partner with other people and organizations across Oregon and Southwest Washington to assist in delivering the necessities to people to get them back on their feet. And we appreciate everybody's donations to them and encourage you to be as generous as possible. Thank you very much. So you want us to go ahead with the program, Gene? Is that
Go ahead. The floor is yours.
okay?
So Eric,
you.
let me open up and explain our first slide, titled Effective Dispute Resolution. Is that appearing on screen, Gene?
Well, it really needs to be run as a PowerPoint. It's just in one little square or one rectangle.
So it doesn't fill your whole screen?
It does not, at least not mine. You're good? Okay, there.
It's filling it.
There we go.
All right, thank you. We wanted to start off explaining the slight change in the title from what was presented when our presentation was announced months ago. It was originally titled Aggressive Resolution Management, Early Resolution Options. We took a step back and said maybe the better, simpler message is we're just going to talk about what we believe is effective dispute resolution. Having been in the settlement counsel business for over 20 years, later adding mediation to our offerings, we've come to have a pretty opinionated view of what are the essentials as you go into a resolution negotiation. And we thought today's theme would be what are the essentials and what we believe attorneys and neutrals alike should focus on to bring to the clients better certainty and clarity and a more likely track to success in resolution negotiations. So with that, we're going to kick off what we believe is effective dispute resolution. Eric, I'll turn it over to you.
So thank you. And thank you again for the wonderful introduction, because I think it short circuits some of where we are. We are primarily settlement counsel, and we came to this, Pat and I met actually 25 years ago, if you can believe it. We both had hair at the time. And we were working in a publicly traded company, having had the trial practice background and working in-house. When we started settlement counsel, it was intended to replicate what we had done in-house, which was go back to the original pre-mediation days and pick up the phone. You hire the best lawyers you can, you pick up the phone and you call the other side and say, do you want to sit down and try to settle the case? After about 7 or 8 years of being settlement counsel, I was approached to mediate a case, and I told them straight up, I don't really agree with mediation. 60% of the time, cases settle despite the mediator. 30% of the time, the mediator is helpful, and 10% of the time, the mediator prevents the case from ever settling, gets everybody out of sorts. So when we say from the client's perspective, everybody, the clients really need clarity. They don't understand the process, and they look to us for leadership. The reason that I agreed to mediate this case after being approached by folks, I said, we'd rather be settlement counsel, but in this instance, I will agree to do it. The case itself, $100 million worth of property, 3 generations that were fighting over it, and it had 2 trials, and they were on appeal and actually ordered to family counseling. I agreed solely if I could interview every one of the individuals without lawyers prior to the mediation because I needed to understand what the client's perspective was. We ultimately did get that resolved, but that kind of leads into what we do and what we think is important is the focus on what the clients need and how to bring more clarity and discipline to the process of mediation. Does that
Eric,
make
I
sense?
think one of the most remarkable things about that particular mediation was that it had been mediated 5 times before. And this was a matter where it was so contentious, the parties couldn't even agree on how to pronounce their family name.
Yeah, I've tried to block that out of my mind, but yeah, that it was remarkable, and ultimately, it took about 5 months, but ultimately we did settle that case, and the family does get together for weddings, funerals, and other reunions. So
But what really came out of that and what that's an example of is how we approach a resolution, which is something we'll get into detail as we go through the presentation today. EDR as a solution is something that we've been a supporter of since the late 90s, probably the mid 90s. It's a common acronym for early dispute resolution. As we mentioned, we like to refer to it as effective dispute resolution. It's been around forever. All the efforts have been positive and admirable, but today we think until a few years ago, it was such a diffused and uncertain process. We we think that there's continuing concern that do mediations really involve the preparation and the focus they need to really increase the likelihood of a resolution? We like to say that if you do the preparation and you go into a resolution negotiation, the case will resolve when it's ready to resolve. It's the preparation and the exchange of information that puts the parties in a position to make the right decisions. So taking a brief look back at our view of effective or early dispute resolution, we trace back to Roger Fisher in 1983 writing a seminal article in the Harvard Business Review, I think it was, advocating settlement as a specialty in the legal profession. And if you read the article, he really focuses on turning to a settlement counsel or an active mediator and taking an aggressive, more active role in making sure the parties are prepared and have the information they need to make a difficult decision. Later, you saw CPR develop comprehensive early case assessment protocols. Later, the ABA Dispute Resolution Early Task Force again did another comprehensive set. The Planned Early Dispute Resolution Group came forward. There's been 20, 30 years of methodologies thrown out. But what we've noticed, and one of the reasons we wanted to participate in this program, is that the last 2 to 3 years, we think all of this effort is turned to execution. And it's led in part by people like the EDR Institute, which is now not only putting out early dispute resolution protocols, but is actively training in them, along with the American Arbitration Association. Then there have been a number of more recent developments that all point towards a building momentum of we think the profession, both the legal profession and the neutral profession, taking a look at what's going on and saying, we need to professionalize this and make a more reliable, visible process for both attorneys and clients.
yeah, so what we have seen is each and every one of these efforts has coupled with clients pushing and becoming more sophisticated about the business and cost conscious, developing a real momentum toward moving mediation up as opposed and having early mediation. But I think the most important thing is getting rid of the bad connotation of early. Well, we don't know enough. We can't do this kind of thing. And if we as mediators, as practitioners, encourage the exchange of information and meet with the clients in advance, we think that momentum can continue. And we've seen that process dramatically increase in terms of our business and mediating prior to suit. But the whole point here is all of these efforts have, I would say it's been a sea change, wouldn't you, Pat? I mean,
The last two to 3 years, this current slide shows some of the developments. We've added an appendix that summarizes what's being done by the ABA, the Federal Rules of Civil Procedure, AAA and EDR training, as well as California legislation. All of these efforts point towards exchanging information earlier and encouraging the parties to, if you will, cut to the chase, not irresponsibly, but with the information that's important to the resolution decision, to the ability to reach a compromise, if you will.
just like Gene talked about at the very beginning, when we all started practicing law, you pick up the phone, you call people in advance. The advent of mediation actually started to chill things. And so people waited to talk until the mediation. You waited,
Yeah.
you couldn't get a trial setting until you had the mediation or set a mediation. We think that we don't have to do that. And now it's time, because the mediation process and all of these efforts have really assisted in getting people educated with respect to how to come together. If we move that up and if we focus on a process that can be repeatable, we think it will get back to what Gene talked about earlier, which is let's talk, let's get this resolved. Let's find out what we really need in order to resolve things.
So Eric, I was thinking that, when we started our, our work as settlement counsel in the early 2000s, we essentially, case would come in, the first thing we do is go visit the other side, sit down with them and see if we could have a meeting to have another meeting. Could we agree that we both wanted to pursue a resolution path separate from the litigation path? What grew out of that was a process that sort of evolved organically. And we initially got tremendous, I think, pushback from the legal profession that, once again, settlement counsel or more active mediation was pressing them uncomfortably into a position that they didn't feel comfortable. We had an aha moment recently, I think, one that you encountered with a firm here in the Northwest that made a comment to you that was pretty striking.
Yeah, we, just like in the settlement council, our first meeting to see whether we could have a meeting again was because most people didn't know what settlement counsel was and were clueless. And that was an opportunity for us to go and educate them. We used that, as I mentioned in the first case that I had, where I met with all the clients in advance. Now it's standard operating procedure. Everybody knows that if they're going to hire me as a mediator, I'm going to sit down and talk with the lawyers, and often find out that we need to sit down and talk with their client in advance of the mediation. As you mentioned, that inflection point for us was probably 3 weeks ago with a fairly large Northwest law firm. A couple of lawyers that I had not worked with at the firm, and I went through my process explaining to them, look, this is why I have the meeting. Sometimes it eliminates the need for a mediation statement. And they said, oh, no, we understand. Our firm actually is, we recommend to all of our clients that we have a call with the mediator in advance. It's like, oh, good. We've at least got one firm who has basically made that their standard operating procedure. As I've always explained to people, why aren't you interviewing the mediator before? And for us, why aren't we sitting down and talking with the client and with the lawyer in advance so we can see what is really necessary to have an effective formal session?
And Eric, isn't it just as important? I mean, it's critical because that lays the foundation of the resolution language, so to speak, that you build the relationship with the clients. But there's a couple important things that come out of those sessions. One, you learn, are those clients, do they have what they need to make an important resolution decision, a settlement decision? And number two, have they had a risk assessment?
Right. And the other piece, again, you can't overemphasize trust. In my initial calls, I explained to them my background, but then I asked the client, tell me about you. Tell me who you are. I'm your advocate in the other room, and I need to hear from you, not from your lawyers, but from you, who you are. And I'll get comments like, well, how far back do I go? Third grade is usually as far back as I ask them. But information that comes from that discussion is critical to the overall understanding of what's motivating the dispute. And then we use words like, okay, well, what else do we need to do to move forward and to help convince the other side? Those kind of words are critical.
So where we could talk for ages about the various steps that might be involved, and we have our protocol called aggressive resolution management. The EDR Institute has 15 or 20 pages of their protocols. Task force has multiple. I mean, there are pages and pages about how to go about it. In the end, we reduce it to 3 key steps that need to happen. How you do it, we leave to the art of your being a mediator and an effective negotiator. But to us, the critical components are pre-negotiation communications, critical exchange of information so that everybody has what they need to make a business decision. And then finally, an open discussion with their legal counsel about risk assessment and outcome analysis. And very often a sharing of that through the mediator.
And, you know, as I talked about the pre-negotiation communications, that's required for me. We have to have that. And that's where we learn what the exchange of information is. Pat, why don't you tell them a little bit about the risk assessment? Because that's kind of the ultimate pulling it all together and forcing each side not to have the same risk assessment, but to at least include the right things.
Well, let's pull up this slide and walk through all 4 components, because I think your comment about the initial communications is critical, because the foundation for being effective, whether it's a settlement counsel, as a neutral mediator, or in any other capacity, including attorney negotiating directly, the communications, the interaction with the client or the party to build an understanding of the issues. And in the end, that client has to trust the mediator or the settlement negotiator in some way, shape, or form. Because in the end, if they get to a yes, it's going to be because they've heard something and they believe it's probably the optimum result under the circumstances. Eric, you want to talk a little bit about your language of trust?
Well, that's I referred to it a little bit earlier in terms of having the interview with the client and understanding who they are and who I am as their advocate. But I use the term we all the time, and I have for years. And only one time have I had a party say, "Well, you call us we, you're not on our team, you're the mediator." Most everybody else adopts that and understands, because we in this room, we in this group need to collaborate to be able to communicate through the mediator to the other side. And so it's not necessarily getting on one side or the other, but helping them understand that I'm really very much on their team, and we need to collaborate and use all the tools we can and give me all the information that I can so that I can effectively advocate on their behalf. I can't emphasize enough that kind of language, as opposed to, well, your client says this, or the other side says this, and then talking to them using that collaborative language actually does develop that trust, and it's very quickly adopted by each side. And it's helpful in terms of eliciting some trust, because at the end of the day, I say, you've got to trust that at the end of the day, I'm going to come to you and say, that's the best I can do. And I never ask them what their bottom line is up front. I say, only you know that, but we will work together to see what we can do to get us a satisfactory compromise. But I also say that I've never had a call by a client afterwards saying, that was so much fun, I want to do that again tomorrow.
Eric, would you agree? The trust not only has to, I mean, you need to build it, but it builds throughout this process. Every step of the way, if you build that initial trust, you find out a client or a party needs something from the other side, there's litigation pending. There's a natural reluctance of the other side probably to produce it outside the discovery in the case. And so you need to forge some sort of process to get the parties what they need, because well, it's pretty obvious if there's some key I don't knows, the litigation process is going to continue and the resolution attempt's going to be unsuccessful. So very often you have to set up a process and the parties have to trust that it'll be a process that'll work.
Well, in fact, Pat, I have unilaterally put off the formal session a lot because the parties aren't ready. And part of that is forcing them to say, what do you need in order to give your client an accurate risk assessment? What does the other side need in order to have an accurate risk assessment? And if they haven't exchanged that information, I say, then why are we meeting? In Oregon in particular, the state rules allow for exchange of the experts just prior to trial. So it's trial by ambush, which I thought was pretty
Still
funny.
alive in Oregon.
Pretty funny coming from Texas, but I tell them, look, you have a choice. You can either try the case or you can share this information so we can play the cards appropriately and see whether or not we can settle the case. And invariably, the clients agree to provide information that they may not normally provide or be required to under the rules in state court here in order to show why the other side should pay them more money or why the other side should not have to pay. It's critical to have that information exchange.
Could we circle that point for a moment, Eric? Because you're now acting differently than most mediators, maybe all mediators, because you're essentially saying to these people, to the parties and their attorneys, we're not going further until you're ready for the conversation we need to have. When you say, okay, you don't have this, you haven't gone through your risk assessment, you don't know where you're going here. When you say stop, you're a mediator that's not taking control, but you're certainly asserting that we're not ready to mediate. How's that being received?
Well, I think people appreciate it most. I had one about 3 weeks ago where they were required to mediate prior to a certain date, court order. And they both recognized that they weren't ready. Both sides needed to have an independent audit done, some other information, and they had to share that and then react to it. But they were afraid of what the court was going to do. So they asked me to provide a paragraph to the court that said, we have had substantive conversations. We are continuing the mediation, but we will move forward in that process, which was true. Because we did have information exchange, we did have substantive conversations. I met with each of them and with their clients to get individually and talked through those things and talked about the information exchange. They both recognized that they couldn't accurately assess the risks, but they also needed cover with the court because, of course, they waited to the last minute to schedule the mediation.
So in the end, the parties and their attorneys generally acknowledge they aren't prepared.
Right.
You don't get a kickback.
And I've told them, if they're not prepared, I'm not going to waste everybody's time and mine.
Let's put a point on information exchange. Pick one example and outline the process that the parties went through, because you're outside of discovery. There's a case pending. How did you protect it and make it safe for the parties to exchange that information?
Well, similarly, I mean, I don't sign on to NDAs, et cetera, but we have the mediation privilege, et cetera. And I basically then, in some cases, say, you need to provide that information to me. And then we'll talk about how or whether to provide that information to the other side. We have a case right now that we've been working on for quite some time. And one of the issues has to do with the financial viability of the company and talking with the officers and directors of the company. What can they share? Sometimes it's a publicly traded company, sometimes not, but you have to worry about the disclosure issues. We set up a process and it's unique. It's not unique, but each one is different.
Yeah.
Where we say, what is it we have to address in terms of the process, procedurally, NDAs, other things, so that we can create a safe space to exchange the information that you need. But that all becomes with the first introductory call, which I say, who's your client? Do you have the appropriate client control? Do you need assistance with that? but most importantly, what do you need in order to give your client an accurate risk assessment? And second, what does the other side need in order for them to have an accurate risk assessment? Because if they don't, then we're going to be like ships talking in the night.
So let's assume that we've gone through the safe information exchange. You talk about the risk assessment. Let's focus on the risk assessment for a moment. You know, in my view, Eric, we've been doing this for 20 plus years, and there's no more critical point in determining whether or not you can really have an effective resolution negotiation. There's no more important point than the risk assessment and outcome analysis. And it's important that it comes from the parties' trial counsel. Our opinion, whether it be as the mediator or a settlement counsel, is important. It gives the sort of a different view to the client, but you have to be able to have a discussion. And what we put up now is what we've developed over the years is our approach to it. And I'd like to take a minute to explain the method to our madness. After having spent 7, 8 years in-house presenting to senior management and a whole range of issues, legal and business. I think and Eric had probably closer to 10 or 15 years in-house. We learned that you only have a limited opportunity and probably one page that you can present to your decision makers. And it's important that you be able to capture everything that's important on that page. And we have found time and time again, as we've approached discussions with law firms, clients, sophisticated and unsophisticated, that they too appreciate the ability to have everything captured in one page. Of
Well,
course,
that's not true of the insurance companies. When I asked
Well,
each side that, can I see your risk assessment that you provided to the insurance company? It is pages and pages and pages. But
when
this
they
is-
do
yeah,
insist on the 20-page risk
Right,
assessment.
right.
But we're a very different process than the insurance department of. No, but let's take a look at this form for a minute, because we very early on, 20 years ago, some clients would say, well, it's important that we use a decision tree analysis or some other method that they had had experience with. And in every case, we ended up having to toss that out and go back to a more narrative approach. And what we do with this is we interview the trial counsel, and we sit down and we find a way to summarize. And the column headings here are just examples, but you summarize the key issues, damages, risks, numbers, and you need numbers, and you also need a probability of prevailing or not prevailing. And a lot of attorneys hate giving numbers, but the fact of the matter is, it's not the accuracy of the number. The number ends up encompassing a view of a case. If your attorney says you've got a 40% chance of recovery or an 80%, that has a profound effect on the client. They need to know that. Another thing that's very important for the attorney and the client to identify is intangibles and other considerations. So often you get into a negotiation, you find out while the dollar amount is important, there may be a personal or business consideration that maybe is equal or more important than the number. In any event, a risk assessment needs to be reduced to concrete points and numbers, and there needs to be a frank discussion between the parties and their attorney. And very often the mediation context, Eric, take them through what you'll do with the risk assessment and the mediation
Yeah,
context.
I mean, this is the same kind of thing. Of course, you developed this. You have to take credit for it because I'm not smart enough. We developed this together, but you did it and have trained me on it. But I use it in the mediation context by asking upfront, what's your risk analysis? Do you have one? Do you not? I always do my own risk analysis the night before the formal session. But what I do is I use this as a process to show the other side, have I considered all the things that are important to you and your client? Put it down in black and white, and then have them take a look at it. Then I put my own together and give it to the other side based upon that. I'm not handing them anything from the other side, but I give them my view of their their case with this risk assessment, including all of the pieces that the other side says are important, and say, what am I missing? So the other side then has to focus on this and say, well, wait, you didn't include this, or I disagree with that. I don't care if they disagree with it. What's critical is that everything has been included. And that way, we have a much better understanding of the importance of the different issues for each side. And I think it's been very helpful. And in fact, I adjourned mediation about halfway through the day because, again, one of the groups said, well, we need to change our risk assessment. And I said, that's fine. You know, I was about to do a mediator proposal, but they weren't ready. They needed to have their client stew a bit about the alternate risk assessment because they hadn't seen some things. And so what I did is I adjourned the mediation for 2 days and came back, for 2 weeks so that they could have a new risk assessment provided to their client, and we settled the case.
Eric, I'd like to refer to this risk assessment, whatever format you use, is the antidote to extreme bargaining positions where you walk in on day one of the mediation and the demand is for $1 million and the response is 1,000. What the risk assessment does is it forces each side to go through their internal math. Sometimes they're willing to share that, sometimes they're not, but that's so important to try to narrow the gap, to tell you as a mediator or us as settlement counsel what we need to focus on in order to see if this case can be resolved.
Oh, it's critical. It does not eliminate the positional bargaining. I have
Well,
tried
insurance is
time and time again. What it does, and you have to keep these, you have to be careful about the confidentiality if this is your risk assessment or theirs. But it gets develops a little bit more trust between the mediator and each of the sides, such that you all kind of see where this may end up. But sometimes we have to play that game and do the positional bargaining, as a lot of people say, well, we have to do the dance. And my response is, well, I only dance with my wife and my daughters, but if we have to do this, I will go ahead and do that. But it is critical. It does help us frame things appropriately. So even if nobody's willing to cut to the chase and minimize the back and forth, I think everybody gets to be closer to being on the same page.
So we see these three tools, these three processes as really prerequisites to the resolution negotiations. And it's only when the parties have all done this are they ready to really mediate or negotiate. And so part of the reason we wanted to present was to convey our view that we think the world of legal disputes, the parties look to, when they hear they're going to mediate, they look at the mediator as, the dispute resolution professional. And I'm going to go in there and we're going to have this process somewhat organized and focused on how to determine if we can settle this case. And over the years, we've become convinced that mediation processes are just too ad hoc and too shoot from the hip. And to the extent the profession as a whole gets to a point where it says, listen, let's adopt some approaches here that convey to the legal community, convey to parties, this is how you go about preparing for a very difficult decision. And our advocacy here is that a lot of what we do is referred to sometimes as resolution advocacy. We're not big on labels. We think this is blocking and tackling. These are things that are common sense. If you were to prepare for trial, I think if you asked somebody if you needed a trial notebook, they'd look at you kind of funny. Same thing should be with a resolution negotiation. If you don't have these tools and these processes in place before you go in, something's not working right.
Well, let me put a point on it. I mean, again, the mediation process is important and it's good and it works. But what it has typically been is you schedule a formal session and you get a mediation statement to the mediator in advance, sometimes a week, sometimes a day. And then the first half of the day is spent educating the mediator with respect to who's here, who's on first, and what the legal arguments are, and nothing, it's a joke. Everybody has to admit, okay, well, we really don't start changing substantive numbers until 3 o'clock. In the last 20 years I've been doing this, I've probably gone past 5 or 6 o'clock 10 or 12 times, mostly because we've done all that work in advance. And people say, well, when does the mediation statement due? I said, well, let's have a call first. That's what we're going to do. And then we're going to talk about whether we need to have a mediation statement. What we really need is a risk assessment. We really need to go through this process. And then maybe we don't need a mediation statement. Maybe we need one for the insurance company or for the CEO of the other company. So it's not filtered by the lawyer. But the point is, the standard mediation process, while good, we think that if you adopt some of these things and get back to the basics that Gene talked about at the beginning, pick up the phone and call the other side and say,
Yeah.
what do we need to do to settle this? Those kinds of things, you don't get anywhere unless you're talking. How, as a mediator, can you really begin to dig in unless you've had these conversations? And I point out one that really hurt me. Remember, Pat, when we were settlement counsel, we went out to New York with a fairly well-regarded group, and the mediator said, well, to our client, I haven't had time to
Oh.
read your papers. Tell me a little bit about your case.
Yeah, what do I need to
And I
know?
said, and how much are we paying you? Ultimately, we ended that mediation relatively quickly. and
Got him out of
settled
the
it.
room.
But that demonstrates, again, the difficulty as a mediator to try, it's too much to say, I'm going to be able to, hocus pocus, settle this today if you get me the mediation statement 2 days in advance and I haven't met anybody. That's not appropriate. We as mediators need to push that forward and help the clients do their work so that we can do our work better. That's my thought.
Eric, one thing I think it's important to point out is because the mediation model and it reflects what we do as settlement counsel, but because it involves that active involvement before the formal session and a mediation, a lot of attorneys will become concerned about costs. And particularly if you're in a jurisdiction or an area where you're charging by the day. You've had countless mediations that have never gone to formal session because you have the initial conversations, you exchange the information. By the time you get through the risk assessment, the parties are at a number or within a range where you can settle without a formal session.
If you put a point on it, I explain that to them and to their clients. The initial calls that I have with them, the other side's not paying their lawyer to have me understand what their side of the case is, and vice versa, as opposed to a traditional mediation where we show up at 9 o'clock or 8 o'clock and they're sitting in a room paying their lawyer to be there while I'm getting up to speak. So it actually is more effective. But you're right, Pat. I had another one which it wasn't even arranged. After walking through the initial steps here, having the calls with both sides, I said, this is stupid. Why don't you tell me what it would take to settle this case and let me see if I can't go get it? So we didn't even have an exchange of numbers. I didn't disagree with what they had asked for. I said, you've got to trust me and tell me what you think is appropriate and what really would be your bottom line. And I hate to use that word because there's no such thing. But they gave me a number and I went over to the other side and we got it settled without any back and forth. But we had exchanged the relevant information, the relevant documents, and I had given them my risk assessment, and everybody recognized the problems and the value of the case, and we didn't have a formal session, so it ended up being dramatically cheaper than showing up for the day. 10 hours of my time, I didn't spend 10 hours on it. I'd spend about 7 back and forth, and we didn't have a formal session.
And another aspect of that, Eric, that I can't help but think of is that I don't think that was possible 5-7 years ago. I think that there has been this change in the dynamic, maybe the change in the acceptance of, certainly we know our business clients demand what we do, but the legal profession starting to recognize that you need to invest in effective pre-mediation, pre-negotiation processes. And in the end, it's lower cost and you'll be in a better position to decide, can the case be settled now or does it have to be settled later?
I agree. Looking back at it, the first case that I mediated, they'd had 2 trials and were on appeal. I would say that today, 30% of the cases that I am hired on as a mediator, cases have not been filed because people recognize that the process that I use works and they don't, and sometimes you want to threaten to file the lawsuit, but once you do that, the bullet's been shot and you've used your best ammunition. So a lot of people say, you know what, before we do this, let's go through this process.
So you're reminding me about how bad we are about what we do. Back in 1997, 98, you and I used to talk about reaching out to potential adverse parties and settling cases before they were filed. We set up this business to do that, and it's only taken us 20 years to get there.
25.
25.
Yeah. But no, I mean, I think that's critical. And, there are a lot of different kinds of cases that you get involved in, but particularly ones that have to do with sexual assault, lots of sensitive information. People don't want to have public. And the most powerful thing that the plaintiffs have is the threat of doing that. For companies, the more I used to represent IBM when I was in private practice, and you got a whole lot more money out of IBM before you filed the lawsuit. Once you filed the lawsuit, that went into the corporate and they paid for the defense. The business unit paid for the settlement. So they never settled once you went to you filed the lawsuit because the business unit didn't want to have the hit on the budget. There are lots of reasons why you want to get together, as Gene said early. Sit down and talk about it and see if you can't get it resolved. We think that the mediators who adopt a more aggressive stance toward let me get educated, let me help you get the other side educated, they will get more business earlier and have more flexibility. If we can all move that forward, we'll unclog the court system. More cases will be tried. It's better for everybody.
I think proactive probably goes down better than aggressive in the neutral business, but proactive, it needs to happen. And our point here in this slide is the mediators and settlement counsel. Everybody looks at mediators and settlement counsel as experts and, boy, you know how to figure out if we can settle this case. So that begs for a process. And we're proposing that everybody should really start to look at what the tools of the profession are and embrace them. And then take a step back and say, hey, if I'm a professional here and people are coming to me to run a mediation the way it should be run to give them a likelihood of resolving this, what do I need to say to them? What do I need to require of them? And how you package that, how you deliver it, there's untold number of ways to approach it. But in the end, you really want to go through this process. You want it to be visible, repeatable, and for your practice to become known as the one that does this because you get results.
But going back to the trust and the words, I think of a case that we had that I had recently where, a couple of business entities over $100 million at risk, and I spent half the day in a formal session after doing a lot of this, and neither side moved. I mean, literally one side moved from 0 to 0 and the other side was out, in tens of millions. And at the end of it, I simply said, look, based upon the information that I have, I think you're going to have to try this case. You're going to win, and I just don't know how you're going to prove your damages. And so they did. They went to trial. And the company that I said was going to win because nobody liked their CEO, they won, but they got a hung jury on damages. Then the judge said, we're going to retry the whole thing. And they came back to me and I said, well, you guys, last time I told you, you need to settle it here. You've seen the trial. I haven't. let's get back to that. And, they refused. So I gave them a mediator proposal and spoke with both of the boards, and they settled for the number that I put out there. Millions of dollars, but ultimately they trusted at the end of the day that my view of that, it forced them to do what they knew they needed to do, but they refused to do it with the other side. Lots of business reasons for it. It doesn't necessarily mean that every case is going to settle quickly, but you have to do that, and you have to have the language to develop the trust so that they'll come back.
Postscript to that, experience taught them they couldn't trust with a trial or a court-ordered result probably wasn't going to get them where they needed to be.
Yeah.
I mean, that was really a sophisticated, complex resolution, but I think the attorneys in the end got to the point where they realized the result in the court was never going to get them where they needed, even if they won. So it forced them back to the table. By that time, you had, it may have been hostile, but they both trusted you, and that's why the case came to a conclusion.
Well, we always tell, look, we got your wish list. We understand that. You're not going to get that in mediation, and you probably know what the walkaway is, but at some point, we'll figure out whether or not you have a decision to make, and let's work toward that. But we have to use these tools to get there.
So our concluding message is we think mediators and settlement counsel are in the best position to move forward with a proactive approach to dispute resolution for preparation for resolution discussions. And we're hoping that the various professions come together in alignment about how to change the dynamic in resolution discussions.
Well, what we've talked about again is all of the ABA, all the different efforts that we've highlighted before, everything's moving there, but we think the mediators in particular are in the best position possible to force this to an earlier conclusion, as opposed to incur the additional costs that often get in the way of settlement. I'll throw in this one last piece where we were, people wanted to hire us as settlement counsel, but the trial team said, well, no, this is perfect. This will work great, but we need to bloody their nose. Well, a year later, we were hired, but the only thing that was the real impediment was the $10 million that the trial team had charged to bloody their nose. Those kinds of things, we've been involved in settled cases where it's $1.5 million a month in attorney's fees on each side. And I'll tell you, one of the worst ones was a week where I had a mediation with $600,000 had been spent in legal fees with four parties, and we moved $15,000 from one side to the other. And 2 days later, two parties, $300,000 in attorney's fees, and negotiated a walkaway. And actually, the clients hugged me. That's wrong. We need to move this up. We need to get those out of the way and done sooner than later. And if we model this as mediators and practitioners and get things done early and have the risk assessments and exchange that kind of information, we can get rid of the cases that need to be settled now.
And I'd like to add a note specifically to bring it all the way down to the other extreme in amount and dispute. EDR Institute developed a set of protocols and took them to the Harris County Court in Texas. And the court has adopted a program where they offer to litigants and disputes of a certain amount. It's much lower amount. I think it may be up to 150 or 200,000. It may be more, but they offer them the right to go into a EDR, early dispute resolution protocol, where they have a specific set of procedures where the attorneys engage in an early dispute process, exchanging information, risk assessments. The point being is that this approach is right, whether the amount in dispute is huge or whether it's small or whether there's no amount in dispute. Parties need to find out, they need to agree on how something's going to be done one way or the other. The method is the same in getting there. The real art of the deal is how you handle your negotiation or how you handle your communications to gain their trust.
We're almost out of time, Pat.
Yeah, we got 5 minutes. We can burn that. So where are we? Many of you would say, well, that's what I've always done. Kudos. Some have called this resolution advocacy. You can throw advocacy on it. Some have called us resolutionaries. We don't think labels help our perspective. The tools we use have been around forever. This is not something new. It's been there forever. We're just highlighting these tools and bringing them into play in a resolution negotiation context. But whether it's old or new, it works. And our final message is let's build consensus and alignment. Let's make this available to the attorneys and the parties so that they can look at resolution negotiations with a whole new appreciation for the process and a greater likelihood of certainty.
I mean, in essence, we as mediators, if you ever get into that situation, and not everybody on the call is a mediator, but ask your mediator to lead, not to react. If you're the mediator, you lead, don't react. Don't let, how many times I've told the parties that I appreciate that, but last I checked, I'm the mediator. And I have two rules. One is everything we talk about is confidential, and the other is this mediation doesn't end until I say so, not you. And that's the important piece, is that we are going to work together to see whether this case can settle. So lead rather than react. That's what I would end with.
So we appreciate your time today. Thank you for listening to us spout off on what effective dispute resolution is.
Does anybody have questions?
Anybody has questions, pop them up.
Yeah, let's just 1 second. Let's stop sharing. Can you stop sharing your screen?
I
No,
believe-
it's not a screen share, it's a widget.
Oh, it's a widget.
Oh, yeah.
Oh,
Yeah,
okay,
it's-
that's
Oh,
it.
fancy. Okay, then, fine. We will go ahead and keep going then.
Well, that
Do
wraps
you
up.
have any questions? We've got 3 minutes.
Uh,
Well, with that, I would just say I've had a lot of thoughts as you've gone through this. I'm sure everybody that watches this or that's here today can think of a mediation and that they attended, whether as the mediator or the advocate for a party, where things just needed to, you keep pushing through, or if more information had been shared earlier, then maybe it could have settled. And those pre-mediation calls or visits, as you might do meetings, those are so important. They make a world of difference.
Well, and the other thing, Gene, that I think is important is this pandemic and Zoom also has facilitated the mediation
Yeah,
process.
yeah.
Don't tell me that the CEO is not available because they can't come out and meet with me.
That's true.
I
Yeah.
can get 30 minutes on their calendar, wherever they are, whenever, to have a brief conversation, and the optics associated with that are important as well. So I hate Zoom. I hate not meeting in person, but there are some real advantages to it, particularly in this context.
Yeah, well, Anna, you have a question?
I did, not a question, but there are resources for the evaluative approach, where you have your series of questions and you start weighing the probabilities. As our wonderful presenters have said, it's a series of very tough questions. But Brandon Ishikawa has a book called Appellate Mediation, which outlines that whole approach. And there are resources. It is really intellectual and emotional exercise, and really outstanding. So thank you, gentlemen. It's a good way to approach the resolution task.
Well, that's another thing, and I mean, we highlight, you can't even find all the resources and put them on the pages, but there are resources out there. The real issue is we all need to execute on it, and we need to take charge as mediators, in our opinion.
Yeah.
And there is a judge out of Georgia. I think he created peacemaker.legal.
Yeah.
for this analysis. He's a very nice person. And that now is finally coming into maturity, if you will, or matured a lot. So there are lots of tools out there, and I think more states are getting on board. California certainly is
Yep.
with the early dispute resolution. So thank you so much for being here, Eric and Pat. A pleasure, and thank you all. Same time next week. We'll see you.
Somebody said they wanted to restate the name of the book that Anna had, so that was in the chat.
Okay. And are you?
Thank you all for your time.
Okay, and please, thank you all for your generosity. The Oregon Food Bank and any food bank appreciates it. Let us know. Thanks so much.